Hello, my name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers, and this is a talk about whether you're protected as somebody who's thinking of blowing the whistle on wrongdoing. First of all, are you protected? Workers will be protected. These are people who work under or have worked under an employment agreement or a contract, or one which is to personally perform any work or services for another party other than people who are your customers if you've got a profession or business. But it also covers home workers and whether or not you do the work personally. It covers self-employed NHS doctors, dentists, ophthalmologists or pharmacists. It will include agency workers, including those working under a personal service company. It covers police officers, student nurses and student midwives, and some NHS contractors and employee shareholders. By sections 191 of the Employment Rights Act 1996 and 193 and 200, members of the Armed Forces, the Security Service, the Secret Intelligence Service and GCHQ are excluded from this definition of worker. Otherwise, you look at section 230 for the definition. On this slide you can see the scope of who is protected. In a case called Woodward and Abbey National plc, 2006 Industrial Relations Law Reports 677, it was held that a detriment which occurs after the termination of employment can be the subject of a claim under the whistleblowing legislation. But the person who makes a disclosure must at the time of the disclosure be a worker. So in answer to the question on the slide, if you're applying for employment and you make a disclosure and you're refused the job, you're probably not covered. However, the detriment itself doesn't have to occur because of a disclosure to your current employer. The current employer may punish you as a result of a disclosure that you made to a former employer. And if that happens, then you will be protected. And there's a case in the Employment Appeal Tribunal, BP against Elstone and another, and its reference is 0141 of 2009. So in order for there to be a disclosure at all, you must convey information, i.e. facts, either in a single communication or in a series looked at as a whole. It's very important that you are disclosing facts. The disclosure can be either verbal, oral, or in writing. It can be in any kind of data, but there must be communication, and it must relate to one of a set of defined types of wrongdoing. So, in order to be protected, you have to have a reasonable belief that the information that you're conveying, such that it tends to show, it's likely to show, it's liable to show, that one or more of the matters on screen, which I'm just going to run through, has taken place or is taking place or is likely to take place. And those things are a breach of the criminal law, so criminal offences, more broadly breach of any legal obligation, a miscarriage of justice, the danger to the health and safety of any individual, damage to the environment, or the deliberate concealment of information about any of those categories. So that's what the information has to relate to. But it can be the wrongdoing of the employer, another employee, a third party, so neither an employer nor the employee, and it can occur either inside the UK or outside. And this will include breach of any foreign law which applies to it. There was a change in law in June 2013. After the 25th of June 2013, a disclosure of information will only be a qualifying disclosure if you reasonably believe that the disclosure is in the public interest. You can still claim that a breach of your own contract constitutes a legal obligation and that you complaining about it gives rise to a protected disclosure. However, after the 25th of June 2013, you've got to be able to show that you reasonably believed that disclosure of it was in the public interest. So you have to have this reasonable belief that the information tends to show one of those listed wrongdoings. This means it doesn't have to prove the wrongdoing outright. It just has to be the type of information that would lead to the conclusion that the wrongdoing has taken place. So in other words, you can be wrong. However, your belief must be objectively reasonable. There doesn't always, in fact, have to be a legal obligation. You must have a reasonable belief, however, that there is a legal obligation. And this was the result of a case called Babula and Waltham Forest College, 2007, IRLL 346. So, your disclosure can be a qualifying one if you reasonably but wrongly believe that one of those listed wrongdoings has occurred. If you believe that a wrongdoing was occurring but it wasn't a listed one, you may still have a qualifying disclosure if you believed that in fact what was going on was one of those listed wrongdoings. You've got to use some judgment consistent with the evidence and the resources available to you for your belief to be reasonable. So you can't simply rely on rumour. And there's got to be some information which tends to show that the wrongdoing has occurred or is likely to occur or is occurring. If you have to go to an employment tribunal, you'll need to show the volume and quality of the information which was available to you when you decided to disclose, because that's going to be one of the factors that the tribunal will look at in deciding whether or not you had a reasonable belief that the information tended to show one of those things. So there has to be some information in your disclosure, and you must have some factual belief. So saying, as was said in Good and Marks and Spencer's UK Employment Appeal Tribunal 442 of 2009, it's disgusting that the employer is doing something or other, may not be enough to enable you to show a reasonable belief that any information tends to show a relevant wrongdoing. That was a case where the employee was saying of an employer's proposal to change the terms of a discretionary redundancy scheme that it was a disgusting proposal. It couldn't show an intention on the employer's part to fail to comply with any legal obligation in respect of the scheme. So let's have a look at the Employment Tribunal's approach to reasonable belief. In a case called Iswaran and St George's University of London, which is Employment Appeal Tribunal 167 of 2010, the tribunal decided that there were three questions which shouldn't be confused. They need for an employment tribunal to be kept separate. So when you're preparing your case, try and separate out these strands. Did you disclose any information? If you did you believe that the information tended to show one of the prescribed matters? And if so, was that belief reasonable? And it's worth noting that hyperbole may well not help you. In that case, the employee asserted that people were going to catch pneumonia from working in cold conditions. But in fact, there's no risk of getting pneumonia from cold working conditions. So suggesting that there is may not show a reasonable belief that information that was disclosed tended to show a breach of the obligation of the employer. If you made a disclosure on or after the 25th of June 2013, it can only qualify as a qualifying disclosure if you had a reasonable belief that it is in the public interest. So it's worth thinking about how the information that you've disclosed has implications for other people. Even if you're wrong about what it shows, it can still be reasonable for you to believe that your disclosure was in the public interest. So if you're gathering information for your tribunal, set out in your witness statement the basis on which you say your disclosure was in the public interest. If you haven't already said it in the first document that you send to the tribunal, called your ET1, your claim form. So remember that it's only that you have to have a reasonable belief that it was in the public interest. Have a look at Chesterton Global Limited, trading as Chesterton, and another against Nur Mohammed, which is an employment appeal tribunal, number 335 of 2014.